पार्षदों, माननीय उपसभापति जी,
नमस्कार। We will take the statutory resolution and the Companies Amendment Bill 2001. They will discuss it together. ओझा जी, चित्रंजन जी, राघवन जी, चालू हो गया था? Oh, good. Mr. Basu. So, Mr. Basu, you continue. यहाँ पर स्प्रे नहीं किया.
Thank you, madam. So basically I had just started, and the point I was making
इसी में कर दो.
that the manner in which the bill is being piloted by the Honorable Law Minister really does not carry the normal attributes with which we have come to associate the piloting of such bills by the Honorable Law Minister. In the sense that the statement of object and reasons itself, which was part of the original bill as circulated for us, the opening statement itself makes a travesty of the facts which actually prevailed and which the government claims has necessitated the promulgation of the ordinance. Now, why I say this? Now, I am not a great expert in capital markets, but my association about now some 6 months with the JPC on the share market scam allows me some insight into actually what happened in the share market. And on the basis of that little experience, though I know it's my obligation not to disclose anything on the floor of this house, which I have come to know of as a member of the JPC. But the fact is, the condition of the share market is better after 11th September than it was before 11th September. Maybe for the last first few days after 11th September, there was further drop, but subsequently the share market has improved. Therefore, the compelling reason for bringing the ordinance is a total sham. And unlike the other share market scams, this time what happened? The Sensex and the NSE index and the index of other markets fell during a prolonged period of 1 year. Mr. Aluwalia, who is a colleague with me on the committee, will bear me out that it was not a sudden development, but indications were there. Of course, there was a sharp fall after 1 day after the presentation of the budget. So, the single purpose of this amendment and the promulgation of the ordinance is not really borne out by the fact, because the whole sequence of events was protracted over a period of 1 year. Therefore, the question comes, why the ordinance? Now, I am totally unconvinced by the argument given by my friend, the Honorable Law Minister, that it is not a fact that it has suddenly happened. It was happening over a period of 1 year, and in fact, subsequent to 11th September, now the share market has actually started looking up. The difficulty is that the government as a whole was not aware, or in a very calculated manner, it allowed these things to happen. Why I am saying this? Because the share market crisis was because of there was systematic rigging of the markets by certain players, by bringing in money, by using illegitimate methods, and all relevant norms and regulations were violated. Now, how do you really, by relaxing the rules for this buyback by the promoters, strengthen the market sentiments? Now, how much the role of the promoters played in the strengthening of the market when it reached a boom of around 5,000 points in Sensex? It was not the promoters' money which primed up the prices of the shares, selected shares, which constituted part of the basket which determined the Sensex. It was the money which was coming in from different sources, including sources which has come to be known as infamously known as the Mauritius route, the OCBs, the way the rules were relaxed, and the government looked the other way. So how has it got to do by allowing the promoters to liberalize the buyback arrangement, whereby sentiments can be again enhanced? I think this is a travesty of truth that the government is making by saying that promoters' buyback will facilitate a resurgence in market sentiments, and the main objective of the government is to save the small investors. Madam Deputy Chairperson, therefore, I would ask the Minister that what is the actual experience of implementation of this ordinance? Between 15th October to today, when the bill is being discussed, how much buyback has taken place? Is there any study made? Has the government been able to evaluate to what extent buyback has taken place, and to that extent how much sentiments have arisen? Because one of the major problems of our share market is, sir, that if you see even during the period of boom, there is no correspondence between the secondary market and the primary market. Normally, the textbook function of a share market is to create a sense of comfort in the promoters that if they come out with a good paper, a booming secondary market will allow them to exit at any point of time when they want to exit. But if you see, when the market was booming, it was not getting reflected in the activities of the primary market. And this year, the situation, sir, is still now, only 6 primary issues have been made. Now, as a government, what is our interest in improving the sentiments of the market? If, because of the market, money can be mobilized for different important projects which will affect our development of the economy, particularly in the infrastructure sector. That is the primary concern of a government. Our primary concern cannot be the well-being of the corporates. Our primary interest cannot be that we will make certain select group of corporates feel happy. I mean, this is the logic, argument advanced so often by our disinvestment minister, that government has no business with all these business activities. Our primary concern is social sector, our primary concern is infrastructure. Therefore, if it so turns out that the only purpose of this amendment is to...
नहीं, उनको तो चेयर की तरफ देखना चाहिए.
हमारा नजर इधर उधर हो सकता है, लेकिन हमारा निशाना ठीक है. तो वही सबसे महत्वपूर्ण सवाल है ना, निशाना सही रहे.
और डिसइन्वेस्टमेंट मिनिस्टर साहब गुजराती की मसल पे चल रहे होंगे, राजा व्यापारी तो प्रजा बेकारी.
So, ma'am, the stated objectives of this government, stated objectives of this government and the compelling reasons. Shuru karu, Gautam Sahab. Okay. I will be more careful. Should be very careful. Now, therefore, I am saying the stated objectives of this government and what this bill purports to do are self-contradictory. It will defeat the purpose. I totally agree with my friend Honorable Sri Kapil Sibal when he says that it will only allow the corporates to shore up their share prices and they purchase at a much lower price today. And I will also ask the Honorable Law Minister through the chair that whether he is aware there are very many serious allegations about the nexus between the corporates and the brokers and other operators in the market. Therefore, can you guarantee this August House that the provisions that you are going to make, because this is end to transparency. Earlier, 77A allowed the corporates to go before the annual general meeting to adopt special resolutions. But here, you are arming the corporates to have the decisions made in the board meeting itself. And what about transparency in corporate governance, which we hear so often about, that corporates will be models in terms of governance, and since government is not properly governing, therefore corporates will be pace setters in terms of enforcing new standards of transparency in this country and so on and so forth. Therefore, I think, it was very unfair on the government, because I am saying that the reasons you show of market sentiments, that was happening over 1.5 years. There was no need to bring ordinance. And you see, ordinance means we cannot apply the normal course of the bill being scrutinized through the standing committee. I think that is very vital. In a country like ours, where there is a multiplicity of opinion, standing committee is a very effective instrument that we have with us for improving the quality of legislation. Now, I know there are people who get lot of happiness or lot of pleasure out of showing that the parliament system here is not working. There is no discipline, no decorum. Therefore, if the house is adjourned due to certain unseemly developments, that makes news. But when we seriously debate out, thrash out issues, they don't find mention in the media. Now, in that context, it is more important to really mobilize all our energies and marshal all our skill in improving the quality of legislation, which in itself can really shame all these misplaced criticism. Now, in that, standing committee is a very important instrument that we have got with us. Now, what was the hurry to bring the ordinance, which denies us the opportunity of this bill going through the standing committee route? Please answer this question. I am not making this point to score a debating point. This is a serious issue which has to be reflected upon by the entire house cutting across party lines. That why should we unnecessarily go for the ordinance route when this instrument is available, when it can be improved upon? And I unfortunately find that the bureaucracy of this country, which has no business, no accountability, it sort of steals our sense of examination, our sense of scrutiny, and whatever helps them, since ordinance route creates a situation whereby a legislation becomes fait accompli on the House, it is thrust upon the government and in its turn on the Parliament. Therefore, I seriously disagree with the provisions of the bill. I seriously disagree with the methods of this bill, and I can definitely say that the effect of this bill will be counterproductive, and it will only help a select group of corporates who have been acting in league with the market operators in the past, which has led the country in such a difficult situation. Therefore, I don't agree and I oppose the provisions of this bill.
Shri Gopal Singh Solanki.
मैडम
12 मिनट हैं आपकी पार्टी के, आप ही अकेले बोलने वाले.
I'll speak less than that.
Oh,
And will
nobody
relax the
else
chair. Sir, I rise to support the bill. It has come out of an ordinance promulgated on 23rd October, amending section 77A, and the period has been reduced from 24 months to 6 months. It is not that it is in the interest of investor or shareholder, but with a view to benefit those people, those who have invested their capital in share, and if there is some likelihood that the market goes down, the image of the companies is also going down, and thereby to benefit those investors by buying it back, their own share out of the reserve fund and the securities thereon. It is one point. It is not that the investor should lose also, and the company can also retain their image among the market, and therefore this bill has been brought. I don't think that there is something wrong, because before pre-11th September, it was not that the market were going down, but we had experienced something among the market also, that is post 11th September, and I think that that must be the main reason to bring the ordinance into force and to reduce the time by 6 months, and therefore this is the best reason that my friend Honorable Minister would also advance it, and therefore I support it. Madam, I don't want to say, but I comment the bill. It will ease the market also. Thank you.
Thank you. Mr. Virumbi, I am pained to tell you that your party has 2 minutes time.
Yes, madam. Just
No,
like
he
an
is-
associated.
He speaks to the point.
Madam Deputy Chairperson, I stand to support the Companies Amendment Bill based on the ordinance promulgated on 23rd October. Madam, when we go through the bill, we got to see the exact situation prevailing in the country, and as well as action taken by the SEBI, RBI and government to remedy the situation. Madam, I too actually little bit allergy for the ordinance, but at the same time, if any new policy has been introduced through ordinance, we got objected. I feel it is not a policy, it is only a strategy to come over the difficulties, what we are confronting in this country. Madam, the situation is totally different. Either industrial productions or in the electricity, everywhere, we had to improve the situation. Madam, the situation, what previously Nilod Bal has said, that the index of the stock exchanges he has quoted. I quote from the another angle, An RBI study published in the October edition of its monthly bulletin shows that corporate sector is likely to end fiscal 2002 with an even lower quantum of investment than the previous year. It estimates that a limited sample of corporations might invest around rupees 54,000 crore, which would be marginally lower than the figure of 55,000 for the previous year. But considering that actual investments in the past have fallen short of forecast, last year, for instance, the forecast was for an outlay of rupees 62,000 crores, while the actual fell short by good of 7,000 crore. Fiscal 2002 might well end and with a figure below the RBI forecast. Therefore, even the target fixed by the RBI, the corporate sector was not able to get the way in which what we have expected to function. It clearly shows that some slowdown. To rectify this, the banks in one side, SEBI in another side, government in the third front, that tried their best. Madam, the banks, they have improved the situation in the functioning from the fact that the gross NPA has been now reduced to 12.4% from 14% of the previous year. That is the gross NPA as the percentage of the total advances given. The net NPA also now it's reduced to 6.7% from the previous year to 7.44%. Madam, to see that the liquidity is little bit faster, the bank rate has been reduced, actually 0.5%. CRR rate, the cash reserve ratio has 200 basic points, that is from 7.5% to 5.5%. By reducing the CRR, the amount released from the banks locked up in the capital of the RBI, now it is more or less 8,000 crores has come to the market. Now the banks has released the money. It has to be availed by the industries. It has to be availed by the production sectors. For that, now there are two ways. One by equity, another by the bond. Madam, if the bond is less risky, the bond as far as the latest concern or latest figures and statistics is concerned, the investment in the bonds has doubled, while the investments in the equity, that is also statistics prepared by the RBI, it has come down to 50%. Therefore, in the equity sector it suffered. The bonds, because that is less risky, it has gone up. When it is so, the equity sector has to be further strengthened. To strengthen the equity sector, the government has taken some actions. Among the actions taken so far, this bill also one among them. In this context, what I feel that the ordinance is essential. Otherwise, if it suppose if the word as it is a usual manner of the bill comes here means it will come some.
You mentioned that the honourable member is always brief and talks to the point. I want to ask why the honourable member is making an exception of that today.
With the indulgence of the chair.
Yeah. Madam, thank you very much, madam. Then, two actions has taken regarding the OCB, previously I quoted. OCB has actually, loophole has been plugged up. Loophole has been plugged up now. Now in the OCB sector, only as an individual capacity they can invest. They cannot take over for right. Therefore, madam, now what I feel that the standing committee, suppose if it goes and gives, I respect the standing committee as other members have. But at the same time, if it goes for the usual process, it won't come within this session, I feel. It may come after next. By the time for the purpose for which the bill has come, this shall be named. Therefore, what I feel that the brought before by the ordinance is not certainly what they feel it. Next thing, madam, however, there is really apprehension about this. Apprehension in the sense, madam, there are one point, before this amendment, there is policy that they had to intimate to the SEBI for that. Now there is no such a thing has been. Yesterday I feel in the business line, they have quoted, I quote, Madam, that regarding the bill, the corporate observers point out, I come to the Kabir Civil now.
That justification was why it was brought as an ordinance.
I see.
So, and now the justification is about the bill itself.
Now the lack on the bill. Madam, the corporate observers point out that the latest amendments to the buyback regulations are, however, silent on the mandatory requirements prior to considering the buyback proposal. The SEBI had decided earlier that companies resorting to buyback of securities with the approval of just the board of directors need to give prior notice to the stock exchange at least 7 days before the consideration of such proposal by the board of directors. But this particular aspect is silent in this bill, number one. Number two, the SEBI board at its meeting held on November 1 had also approved modification to its buyback of securities regulations, requiring the companies to communicate the decision of the board to stock exchanges within 15 minutes after the conclusion of the meeting. This decision is also not reflected in the latest amendments. The reason for this silence in this bill may be addressed by the Honorable Minister, I suppose, and enlighten us. Therefore, a corporate observer pointed out SEBI might well enforce such norms through amendments to the listing agreements. SEBI officials were not available for comment, they said. But what now the corporate observers, they are expecting some amendments through SEBI, not from the bill. Therefore, in this sector, I hope Honorable Minister will explain us why these two areas are silent in the bill. At the same time, I feel this is most essential. It is brought before us at the appropriate time to see that the investment is further enhanced in the corporate sector. I therefore totally support the bill. With these words, I conclude. Thank you very much.
Shri Fali Nariman.
Madam Deputy Chairperson, the brief point on which I wish to intervene, Madam, is not the substance of the bill, but to draw attention today to the frequent use of the power of promulgating ordinances. The Companies Amendment Ordinance of 23rd October has now become a bill. It will in due course be passed, and so be it. But let me emphasize what is already well known and may be well be said to be elementary, but sometimes the elementary has also to be emphasized. The making of laws under our Constitution is a legislative function, not an executive function, both at the center and the states. And we have all repeatedly pledged ourselves to a parliamentary system of democracy. Making of laws when Parliament is not in session is an extraordinary power conditioned by government's satisfaction that circumstances exist which render the taking of immediate action necessary. Of course, government is the best judge of this, but not the sole judge nor the final judge. The final judge is Parliament, because the law, when made, must be laid before Parliament, because the operation of the ordinance lapses on the expiration of 6 weeks from the reassembly of Parliament. What is this for? This is in order to ensure control by the lawmakers of the law-making function. I would submit we should make this control more meaningful. It should not be merely ritualistic as it has been in the past. I do not go into the reasons in this case for promulgating the ordinance given by the Honourable Minister when speaking on the bill. I will assume that they are correct reasons. But I submit we should all know whether those who drafted the ordinance were actually conscious of the reasons for invoking Article 124, and we must all be told of those reasons earlier so that they could be appropriately addressed when the bill is introduced. There is much too frequent use of the ordinance-making power both at the centre and the states, and I would submit for the consideration of this Honourable House whether it would not be more appropriate and proper to require the exercise of this ordinance-making power to be actually conditioned by a statement of reasons attached to the ordinance mentioning the precise circumstances which exist that require the taking of immediate action to enact a law. Not a mere repetition of the formula, but someone must apply his mind to the precise reasons why immediate legislative action is required to be taken and to state it. This would help check the overuse of this power of making ordinances, especially, Madam, since the Supreme Court has now held that an ordinance, when promulgated, remains a valid law, even though it lapses on the expiration of 6 weeks of the reassembly of Parliament, and all acts done under such a law are valid. This is the only way in which we can assert our commitment, which we keep making, both outside and inside the House, and only last Sunday in the Central Hall, to a parliamentary system of democracy. Debating on a measure which has already become a law is not at all the same as debating a bill which is to become a law. As has been pointed out, there are so many changes that may be suggested, a consensus may be reached, as is often done, and that's the whole essence of a parliamentary function. The importance of this House, I respectfully submit, whenever ordinance is resorted to, gets diminished. I submit that the power under 124 should be guided and controlled, and the only body that can guide and control it is this House. Thank you, Madam.
Thank you. That ends to the discussion. Mr. Minister.
Madam, I am extremely grateful to several honourable members of the House who have expressed themselves at length on this particular bill. Madam, the object of easing the buyback procedure is really to add to the liquidity in the market and also use some reserves of the company, which is a transfer of that corporate wealth for the benefit of the shareholders. Several questions have been raised. I will try to deal with each one of them. The honourable member who spoke towards the end raised an issue from an article in the Business Line as to why within this statutory change a provision had not been made that stock exchanges are required to be intimated every time a buyback does take place. Madam, we are not adding or altering the whole scheme of buyback. Buybacks as a concept under the Indian Companies Act was introduced in the year 1999. Whatever are the requirements in relation to the buybacks, they do remain, except for one basic change which have been brought about, that is 10 out of those 25%, that is the maximum which is permitted, can be permitted by a resolution of the board rather than the original decision wherein it was required a special resolution of the AGM of the company. The requirement to intimate the stock exchange, even under the original law, was not a part of the Companies Act, but is a part of the listing agreements guidelines which have been issued by the SEBI. And those guidelines under which intimation has to be made, any decision of the company's board which alters the prices or alters the nature of the securities or the quantum of securities is a major decision by the board itself, and under the listing agreement guidelines of the SEBI is required to be necessarily informed to the stock exchange. That guideline remains unaltered and need not be substituted within the provisions of the Companies Act itself. Madam, a question has also been raised as to whether there is any kind of alteration in the concept of corporate democracy. In the scheme of the Indian Companies Act, there are several powers which are exercised by the board. There are several powers which are exercised by the AGM of the company. A board is a donee of the jurisdiction which the Companies Act confers upon it, or the jurisdiction which the AGM may decide to confer upon it. The fact that there are two different organs under the Companies Act which exercise respective powers does not in any way show that the corporate democracy in any manner is being altered. Quite to the contrary, when 10% of these powers are being exercised by the board, that's a power which now under the Companies Act itself is exercised by the board, just as several other acts are exercised by the board itself. There are several powers which are under the Companies Act jurisdiction of the board itself. That does not mean that the Companies Act corporate democracy in any way stands denuded. Mr. Sibal raised a very important question, whether this could be at some circumstances misused by a set of promoters for their own benefit or for the benefit of persons close to them. Let me just explain how this will really function. When a company decides to buy back either 10% under this change or 25% under the original law, the price at which it will buy back is not the price which the company decides as a predetermined price. The price varies from a day-to-day basis as far as the stock exchange is concerned. The price is decided by the market itself. A company may well start buying back. It may be able to buy 0.25% on one day, another 0.5% on another day, and as the purchases continue to increase, it is anticipated on reasonable market behavior that the price of shares, because of addition of liquidity to the stock market, as also the demand of that particular share being increased, the price can move up. Once the prices go up, Mr. Basu raised a question, what is your experience that why will this itself lead to an increase in prices? This itself, Mr. Basu is right, is not a complete answer to all problems which exist in the stock exchange. Several steps are required. And he's absolutely right when he says the credibility of the stock market operations in India has to increase and improve for the ordinary investor to have faith in that credibility and become an investor. But adding to the liquidity of the stock market, converting certain reserves into the liquidity process in the market, creating a demand for the shares of respective companies, and once there is a demand for a large number of companies, because a large number of companies may go in for a buyback. You asked a question, how many companies have done it in the past? I tried to check up under the 1999 change law.
After October 20th.
No, I'll answer the question. A total amount of 1,467 crores by a buyback process was added to the liquidity of the market after the 1999 buyback changes. After October 23rd, let me give you two figures. The values on the stock exchange, and again I am saying, values are not determined on the stock exchange by one factor alone. Sentiments do make a difference. Future potentials make a difference. Steps taken by the government may make a difference. Improved prospects of a quarter may actually make a difference. Performance may make a difference. FII investments may make a difference. There are several factors which add to it. On both counts, I found out, we have so far, through this intimation by the disclosure scheme, received intimation that under the new ordinance, already 3 companies have intimated to the stock exchanges that they have decided to utilize it for the purposes of buybacks.
They have not done the buyback yet.
So the buyback process will start once it...
in other words, after October 23rd till date, there is no buyback yet by any
The
company.
process starts.
I'm only
The
asking
process
a fact.
starts. Very well. The process starts. Whether the buybacks have started or not, but we have intimation of resolutions.
I'm sorry.
We have intimation of board resolutions of 3 companies so far.
In your original statement, you made a solemn statement on the floor of the House that already, because of buybacks, you think that the share prices have gone up. Which is why I asked the question. So it's now clear that there has been no buyback after October 20th.
Allow me to complete. A buyback process under the original special resolution process has been going on. I've given the figures. Under the new change, 3 companies have already availed of it. We have intimation of the board resolutions. On account of several factors, and this is one of those factors, from 23rd October till date, the percentage change in the value, in the Sensex figures itself, there has been a noticeable improvement. The figures are also before us.
I think again you are getting the facts wrong. Facts wrong because...
Let him complete.
No, he is giving certain, no quarrel. I am just pointing out. Look, one is that, see, the contribution of this new ordinance is minuscule in this whole thing, because the share market had come to its rock bottom. I mean, it could not further go down. And that 1,400 crores, the figure you are getting, it is also totally insignificant in terms of the total amount of the loss that has taken place in terms of market capitalization. It is also insignificant as compared to the amount of liquidity that was artificially generated by the brokers, sometimes in nexus with some of these promoters at the time when the market boomed.
Madam, just give me a minute. In fact, our inquiries have in fact revealed that in the past, and the minister is right, the price will be determined by the market. In the past, what has been happening is that companies have been using certain institutions, I won't take their names, and certain entities to jack up the price of a particular script, so that when the price is high, they can purchase those scripts to benefit themselves and buy those very scripts when the price goes low a week hence. So the point that I am making to the Honorable Minister is that this is precisely why This is precisely why we are subjecting this bill to the caveat that we have placed before you, namely that this is going to be used by promoters for the benefit of their members of the family and to their associates.
महंगा होएगा तो क्यों खरीदेंगे? सस्ता होगा तब
क्योंकि
खरीदेंगे ना।
कैश रिजर्व से अपने आप को पैसा देंगे। सिंपल, आपके पास 30% अगर स्टॉक है अपनी फैमिली मेंबर्स या आपके एसोसिएट्स का, तो उसको हाइक करके कैश रिजर्व्स कंपनी से उनको पैसा दे देंगे और वही शेयर फिर जाके मार्केट में जब दाम सस्ता हो जाएगा सस्ता खरीद लेंगे। ये तो साफ जाहिर है और ये होता रहा है। दिस इज पार्ट ऑफ द रीजन ऑफ द स्टॉक मार्केट स्कैम।
ये मंत्री जी
मैडम
इसीलिए
may I elaborate?
मंत्री जी मुंह में हंस रहे हैं इसीलिए।
Let me elaborate, because the illustration quite is not as explicit to be.
सुझाव क्या है? आप सुझाव दो।
एक मिनट, गौतम साहब। Madam, the buyback adds.
Let me hear.
The buyback adds to the liquidity of the market. The buyback generates demand for the shares of a particular company which is being subjected to a buyback. The buyback benefits the values in terms of all shareholders of the company. Here you have a company which has large amount of reserves. The price is quoted at a price even lesser than the reserve as the balance sheet price. The shareholders have no option but to sell it at the depleted price, at the depressed price. Once the company indulging in a buyback starts buying and generating the demand, these shareholders have an option to sell, the prices move up. It benefits the shareholders who are going to sell. The shareholders who are not going to sell and who have a capacity to hold on, the corresponding value of their shares also increases because the shareholding base of the company gets contracted, gets reduced to the extent of the buyback. So this kind of an illustration that promoters will start selling their shares, the tendency of the promoters, it's a well-known fact, the general tendency of the promoters is not to sell but to consolidate their holdings. Promoters remain in control by consolidating their holdings, not selling their shares in the market and reducing their holdings. So this kind of an illustration which Mr. Sibal mentions, in a hypothetical case, if it is possible, it may be some promoter who's defying the normal market logic. This actually goes to the benefit. This normally, promoters consolidate their holdings.
The promoters will manipulate the market. It is
well, promoters manipulate the market. The promoters will be taken to task for that.
If you
Let him complete.
The promoters who manipulate the market will be.
Why Mr. Nariman, the honourable member, suggested bills of this nature should not be introduced the ordinance route, because we need a thorough discussion of bills of this
Because we
nature.
are having a discussion on
But
this.
this is no way, because you
We
need
are
to
having a
send it
discussion
to
on
the
this.
standing committee.
We are having a
What kind
discussion
of-
on
this is the problem.
Therefore, madam, the normal principle behind a buyback is that buyback not only adds to liquidity but creates a demand. It raises the prices of the shares, and small investors of a company who otherwise had no option but to sell at the depressed prices today have a better option. Shareholders across, whether they want to sell, they want to hold on, are going to universally benefit once the market sentiment itself improves. And the fact of the matter is, amongst various factors in the last few weeks which have contributed to a somewhat improved market sentiment, this certainly has been a step in that direction. Mr. Nariman, madam, made a very valuable observation with regard to ordinances. I completely agree with him that the normal rule being ordinances are not to be resorted to, particularly when subject matters are of such a nature that they can always await when the parliament assembles and they can be taken up in parliament. The government is very conscious of this. And I can tell him that every time a suggestion for an ordinance comes, one of the first questions we address ourselves, can it not wait for the next session of parliament, or is it so urgent that it must actually take place before the parliament is ready to assemble? Here is a situation where the market sentiment, which since the month of March this year was already depressed. March this year, please. March this year, because the Sensex value was over 4,500, around 4,200 during that period. Market sentiment, which was depressed since 15th of March, particularly this year, after 11th September, world over, steps were being taken when the markets went down. Several steps were required to be taken to improve the market sentiment, and therefore this was a matter which required to be dealt with, and that is why the government overcame this initial view that we have, that normally we try and issue ordinances, that we did issue this ordinance in the middle of October this year, so that the market sentiment itself could be somewhat responded to, and that in some measure or the other has responded to the market sentiment having improved. The market at one stage was as low as 2,600. Even when the ordinance was issued, it was less than 3,000. The market sentiment since that period of time has to some extent improved. Madam, with these observations, I commend to the Honourable House that our experience of this ordinance has been that this is going to help the market and therefore help the small investor. The House gives its approval to this particular bill.
I think this itself is a scam. If the minister doesn't respond to this fact that the promoters can transfer the wealth which is with the companies into their personal pockets via this mechanism, and the government is helping this scam. Someday, all this is going to boomerang on this nation. We have been trying to do something like this for last several years. First time when the government decided that the public sector corporations should go into the market, buy the shares, and we had Harshad Mehta scam. Thereafter, continuously, we have seen number of occasions on which the government is trying to bring in regulations which is going to affect the market in the manner we will totally destroy our capital market and our capital structure and the capital formation process. This is a warning, and I think the government should respond.
And Madam, I think factually also.
Now I have to put them.
Let us bring this into record.
But you have
Between
opposed
March
it.
2000 and March 2001, the Sensex shed 1,000 index points. And it is not just after the presentation of the budget that it happened. It was happening for one, so the market sentiments argument that I think this is totally misplaced. The argument is totally misplaced.
1999 amendment.
1,000 points the market lost during 1 year.
Madam, they are very much confused.
Now the whole...
Not discussing it here.
You are trying to confuse us. You are trying to confuse us. But the fact is,
and simply all
There is a procedural law, madam. You have a buyback system operating since 1999. There is a simplification of procedure, and some honourable member, I would request him to be slightly careful about his phraseology, to say a simplification of a procedure is a
Facilitate the
scam.
corporate promoters. To
The
facilitate the
Lok
corporate
Sabha
promoters.
unanimously approved it, and that's a scam.
We are absolutely clear what you are trying
That's
to do.
certainly not procedure.
I have a simple answer or solution to it. There is a statutory resolution opposing it, and there is a bill before us. They both have been discussed. If you want the voting, we can have the voting and solve the problem. But instead of having allegation.
Not of voting. Basically, we don't want to stand in the way of the government. If they want this experiment and hope that it will work, we'll support them. But we only wish that they had not taken the ordinance route. They had gone through the normal legislative process. We would have had a better discussion on it. We would have been able to exchange our views and facts. We are not opposing it. Yes. That's all.
The point which he has made, we have taken very serious note of it.
Thank you.
And you will consider it. Now,
I respect the seriousness of the minister and not the government.
it's a joint responsibility. So you have to take the government along with him. Now the resolution which was moved, Shri Arun Jaitley, you have moved it. Now the statutory resolution, the motion for consideration is being taken. I shall put the resolution moved by Shri V. Raghavan to vote. Are you going to
I
withdraw?
sincerely hope the Honorable Law Minister will discourage the rush to ordinances. With this hope, I withdraw my resolution.
Has he the permission of the House to withdraw? The resolution is being withdrawn. I shall now put the motion moved by Shri Arun Jaitley to vote. The question is that the Companies Amendment Bill 2001 as passed by Lok Sabha be taken into consideration. Those in favor, please say aye. Those against, please say no. I think that I think the ayes have it, the ayes have it, the ayes have it, motion is adopted. We shall now take up clause by clause consideration of the bill. Clause 2 to 4 stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 2 to 4 are adopted. Clause 1, the enacting formula and the title stand part of the bill. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1, the enacting formula and the title are adopted. Shri Arun Jaitley, to move that the bill be passed.
But I move that the bill be passed.
Motion move that the bill be passed. The question is that the bill be passed. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it, bill is passed. If I go, Mr. Nilotpal Basu, if I had gone for the voice, then there was only one voice saying yes and one voice saying no. So I would have to have a proper voting done. That we'll have to measure, that how loud it was. And then we'll have to measure how committed it was. Now we have the Indian, I have one problem before me. There is a bill which Mr. Satyanarayan Jaitley has brought before us, the National Commission for Safai Karamcharis Amendment Bill. I went through the bill, there is really nothing in it. I mean, it is nothing in the sense that nothing controversial in it. Now, Mr. Jaitley has a problem because the Vice President, the Chairman of Rajya Sabha, is presiding over some function where Mr. Jaitley has to be there. It is his program. If the House so agrees, and if nobody is, discussion is required.
The other House also, long discussions.
No, it was very short bill. It is
I am
to extend the time only.
they don't have the discussion. What I am saying,
Madam, it is about Safai Karamchari.
okay,
Have the discussion later.
the whole trouble, just a second. The whole trouble with you is, could you please listen? Yes.
Only to extend it.
It's sometimes the chair has to have the attention also. Or you also have to the attention of the chair. The thing is that there are many bills in between. Now what Mr. Jaitley requested me, that after we finish the succession bill of Shri Arun Jaitley, I should take it before. There was nowhere any suggestion yet you pass every bill. I know you are very concerned with the Karamcharis, whether Safai or otherwise. So your sentiments have been taken care of. Now we'll take, if the House agrees, after Mr. Jaitley's bill, we'll take that. That is the only thing. The Indian Succession Amendment Bill 2001, Shri Arun Jaitley. Agreed.
But now I beg to move that the bill to amend the Indian Succession Act 1925 be taken into consideration by this Honorable House. Madam, the Indian Succession Act 1925 was aimed at consolidating the law relating to testamentary and intestate succession as was prevalent at that time in our country. Chapter 2 of Part 5 of this Act deals with intestate succession of Christians. There are two particular provisions which this bill seeks to amend. Section 32 recognizes the Christian widow as one of the successors to succeed the property of a deceased husband. However, there is an explanation attached to it, and the effect of the explanation is, if at the time of the marriage there is an agreement between the wife and the husband, in that event the wife on becoming a widow will be excluded from her husband's succession. This, madam, was originally conceived to be something which would have been opposed to public policy, but because there was a specific statutory provision in 1925, this has been sustained. We have been receiving various demands that this should be done away from the statute book, and such a provision should have no recognition of this, particularly in the present age. The Kerala Women's Commission, several other non-governmental organizations, and various Christian organizations have been representing to the government that this provision should be, this explanation should be deleted, and a Christian widow should be entitled to succeed to the property of a husband, particularly if he dies intestate. The second provision is with regard to the provisions of section 213 of the Indian Succession Act. This is intended to bring the Christians at par with other communities in the country. The provisions of section 213 require, it is a provision which doesn't apply to the Muslims. It also doesn't apply to Hindus, Jains, Buddhists, except a certain category who live in certain 3 of the metropolitan towns. Since there has been no demand as yet in relation to that category of the Hindus, we are not looking at those amendments at the moment. But with regard to Christians, an exception has been carved out that upon the death of a Christian, there is a probate mandatorily required by his successors all over the country. This is a long drawn out process where a Christian heirs have to go to court, spend money on litigation, and then get an order of court to enable them to succeed to their predecessors' interest. Some months ago, I had received a representation which was signed by Christian members of parliament belonging to both houses, about 23 of them, wanting the change in this particular provision. I thereafter consulted various other organizations of the Christians. They were also in favor of this change. The Law Commission, in its 110th report, the Christian Women's Commission, members of parliament, other community leaders have all been requesting us to make a change to this provision, and therefore there is a second amendment which has been introduced, which is to bring Indian Christians at par with the words Mohammedans used in section 213, so that they are also not expected to go through this cumbersome legal process before succeeding the property of their predecessor in interest. Since this is a provision which seeks to help the community and also delete one provision which is now considered unconscionable with regard to excluding widows from inheritance of a husband's property, I request the Honorable House to take it up for consideration and passage today.
Now, I have one objection to it. It's as the bill is of 1925 and we were under a foreign rule, the word Mohammedan was used. Now, no more this word is used in our country. We are, the Muslims are known as Muslim, non-Mohammedan. So you should delete this word and change it to Muslims. Because there are no Mohammedans.
I will, since this is a pre-independence legislation,